Mr. Chairman, thank you for your leadership. Thank you for coming to Florida so that you could receive direct testimony. You did that early in this year. And we have just closed a very ugly chapter in Florida political history, a chapter that occurred over the last 2 years of an attempt to suppress the rights of voters, to suppress that vote. And I want to bring you some proof today. First of all, I'd like to submit my written statement for the record. I'd like to submit for the record a summary of what I'm about to say that came in the Palm Beach Post in their Sunday, October 28th, 2012 article, an investigative piece. And thirdly, I would like to submit for the record the deposition of an Emmett Mitchell IV, serving as the general counsel for the Florida Republican Party, when he gave a deposition in the case styled State of Florida versus United States of America, a deposition that was given earlier this year when the state of Florida sued the U.S. government for court determination of the pre-clearance under the Voting Rights Act of 1965, pre-clearance of 5 counties for discrimination, and further sued the U.S. government by questioning the constitutionality of the 1965 Voting Rights Act. In the discovery for that case, the testimony was taken of this former general counsel of the Florida Republican Party. And what I would like you to know is this key individual who, with your permission, with the committee's permission, I'd like to insert those documents in the record, that his testimony given in April, Mr. Mitchell said, and it's in the sworn testimony, that he was asked to draft the original version of the legislation that became law. He was asked to draft it by Republican Party leaders, specifically after consultations with Andy Palmer, then the executive director of the Florida GOP, Frank Terra Firma, head of the GOP State House campaigns, and Joel Springer, head of the state Senate Republican campaigns, and in early talks with the executive director of the Florida GOP. And with this full testimony, you will see that there was a deliberate effort to change the election law of Florida in order to do a number of things. Now, it wasn't the first time that Mr. Mitchell's name has surfaced with voting-related controversy, because back in the infamous 2000 election, when there was the state of Florida's efforts to purge possible felons from the voter rolls, and that effort led to thousands of eligible voters being turned away at the polls during that presidential election year because their names were removed from the polls. I said thousands of eligible voters who were purged. This latest election law was introduced and passed in spite of the vehement opposition of the elections officials in the counties that conduct the elections, the supervisors of election. They collectively, through their state association, and a wide array of other groups had vehement opposition to the proposed bill that became law, reducing the number of early voting days from 14 to 8, which very conveniently eliminated the Sunday voting before the Tuesday election, which a professor, Dan Smith from the University of Florida, testified at your hearing in Tampa, in fact, that his investigation, his university investigation found that there were two particular groups that utilized in the history of Florida early voting over the previous decade Sundays as the time that they voted. One was African Americans and the other was Hispanics. That was one thing the legislation did. The law also made voting harder for people who had moved from one county to another and had a different address, because when they showed up to their new voter registration, if they did not have in their documentation, such as their driver's license, which likely they had not updated from their old address, if it was a different county, they were not allowed a ballot. They were given a provisional ballot, and we know from the 2008 election of the provisional ballots cast, 1/2 of them in 2008 were thrown out. Now, as a result of the new voter suppression law, you've already stated it, Mr. Chairman, long lines, an avalanche of provisional ballots, court challenges, all of it has come to pass. You're going to have to draw your own conclusions, Mr. Chairman, in this committee, but it's pretty straightforward for the senior senator from Florida. Florida's 2011 election law changes were politically motivated by the documents that I submit today, and they were clearly designed to disenfranchise likely Democratic voters, and not, as the Republican sponsors in the legislature contended, to prevent voter fraud. You will see in the documentation where Mr. Mitchell, when asked directly, do you think that voter fraud is a problem? He says no. When asked on voter registration that eliminated organizations like the League of Women Voters for 1.5 years to stop their registration of voters because it changed the previous law from 10 days to turn in the names to 48 hours, which also added a huge fine for the person collecting the signatures if they didn't get it in 48 hours. By the way, 48 hours included Saturdays and Sundays. And when asked in this deposition, did in fact you think that 48 hours was long enough? He says no. He felt comfortable with the 10 days. And so, Mr. Chairman, I thank you for the opportunity that I can bring this documentation to you, setting the stage for testimony that will follow me by the panel. And don't forget that what I'm telling you about that happened in Florida took place against a backdrop of a broader Republican-led campaign to restrict voting in at least a dozen states. And those were states that were controlled by the Republicans, and they approved new obstacles to voting as part of a campaign that was linked to the American Legislative Exchange Council, ALEC, which receives substantial funding from the Koch brothers. And so Mr. Chairman, I conclude by saying that singling out Americans, stopping those or trying to stop those as they failed in Florida because of the 7 hours that they stood in line that you already noted, in trying to stop them from going to the polls, this is against the American way. It's against one of our most precious rights, and it's against what is guaranteed to us by the Constitution of the United States. Mr. Chairman, I thank you for the privilege of being here.